Okay, let's unpack this. Today, we are undertaking, well, a truly massive deep dive. We're looking into something incredibly foundational.
Hmm.
Foundational to law, to ethics, civilization itself, really. We're talking about the historical and legal protection of minorities.
Right. And this isn't just a regional history lesson.
No, not at all. We are chasing a universal ethical thread. I like to think of it as a kind of blueprint for moral governance that, cuts across 14 centuries, 3 continents.
And completely diverse legal traditions. You're going from religious charters all the way to secular constitutional law.
Exactly. Our mission today is, I'll admit, a bit ambitious. We want to try and extract the core, that enduring principle that defines what a civilized legal order actually is.
I think the key question is the one the source material keeps coming back to.
Yeah.
When does law stop being just a tool of power?
And start becoming a shield for the vulnerable. So we're diving into a comparative study. It's fascinating. It places these landmark legal decisions right next to each other, and it examines how political power, whether it's ancient or modern, is constrained by this moral duty.
A duty to protect the few, the different, and, well, the weaker.
And the sources we've aggregated trace this thread through 3 foundational, very distinct pillars. They are these moments in time when the judiciary, or the sovereign, consciously checked the majority's impulse to dominate.
Mm-hmm.
So our first pillar is this revolutionary blueprint from the 7th century. We're talking about the foundational document of the Islamic State, the Charter of Madinah.
A huge starting point.
Then second, we jump over a millennium. We're going to the 20th century, right into a battle for individual conscience in the USA. That's the 1943 Supreme Court case, West Virginia State Board of Education v. Barnette.
A classic.
And finally, we're looking at a crucial modern affirmation, a proactive judicial mandate from just a few years ago in the 21st century, Pakistan's Supreme Court minority rights judgment in 2014.
What's so fascinating here, what really, I think, drives the depth of this deep dive, is the central thesis of the source material. It forces you to compare judicial ethics directly.
Directly?
Yeah, the ethics of an Islamic caliphate's foundational structure, right up against the ethics of a modern Supreme Court in a democratic republic.
Right.
It argues that the true test of sovereignty, the why, this all matters. It's not measured by the majority's wealth or its military might.
Yeah.
It's measured by how it structures the legal environment for its minorities.
That framing, it just immediately elevates the whole conversation, doesn't it?
It does. It suggests that this whole struggle for fundamental rights is not some neat linear progression that started at one specific moment, like, the Enlightenment.
Right. It's not just a Western story.
Not at all. It's an enduring universal challenge of political power. Every state, whether it's a tiny, nascent community in 692 CE or a global superpower in 1943, faces this profound temptation.
The temptation to impose uniformity.
Exactly. To leverage state power to enforce a national or religious dogma. And the moral maturity of that state, it's defined by the resilience of the legal structures it puts in place to actively resist that temptation.
That resistance. That shield for the few. That's the core we're trying to analyze today.
That's it.
It sets the stakes incredibly high. The argument is that the moral strength of any nation is defined entirely at its margins. So let's start right there at that foundational moment, 1400 years ago.
Okay.
We're traveling back to the year 622 CE. This moment isn't just about the founding of a religion, it's the establishment of a state, a political entity in Medina led by the Prophet Muhammad.
And you have to understand the context. It's crucial.
Right, let's set that scene. Pre-Islamic Arabia was, it was defined by these intensely localized tribal systems. Loyalty was determined exclusively by your bloodline.
It was everything. Who you were was who you were related to.
So when the Prophet arrives in Medina, he's inheriting this deeply fractured political landscape. You've got various Muslim immigrant groups, you've got local Muslim converts, and then you have these established Jewish tribes with ancient roots in the area.
A real melting pot, but a fragile one.
Absolutely. Unity was essential for survival, but to get there, it required some truly revolutionary legal thinking.
Indeed. And that's where the Charter of Madinah, or the Sahif al-Madinah, comes in. It was, for all intents and purposes, the world's first multi-ethnic, multi-religious constitutional document.
The first.
And the source material really highlights this one clause that was genuinely unprecedented for its time. You have to remember, other great empires of the day, the Byzantines, the Sasanians, they all operated under these rigid religious or ethnic hierarchies.
So what did the charter say?
It declared, and I'm quoting here, "The Jews are one community ummah with the Muslims. They shall have their religion and the Muslims theirs."
Let's just pause on that. One community.
If we really unpack that single statement, the revolutionary weight of it is staggering. In the 7th century, citizenship and community, they were almost universally based on a shared faith or shared ethnicity.
Right. You're in if you believe what we believe or if you're one of us by blood.
Exactly. So to declare a non-Muslim minority part of the founding community,
Mhm.
the Ummah, while at the same time guaranteeing their total religious autonomy and legal distinctness,
Mhm.
that was a radical act of pluralism.
It was a conscious choice then to build a state not just on a shared creed.
But on shared residency, shared loyalty to the new state,
Yeah.
and a constitutional agreement. It's a political identity, not just a religious one.
And the source material is clear that this wasn't just, some political appeasement to keep the peace temporarily. It established a profound legal precedent.
A permanent one.
This was, as you said, the very first time in recorded history that a Muslim majority guaranteed the constitutional rights of a non-Muslim minority. But I have to ask, what about the immediate political fallout? Surely, setting up a full framework for pluralism like this must have created massive internal resistance from tribes who preferred the old ways of absolute identity rule. Did the source material address how the Prophet managed that internal opposition?
That's a great question, and it gets to the legal strength of the Charter. The source is very clear on this. The Charter transformed the commitment from something that could be seen as, political expediency.
Into a fixed constitutional and ethical duty.
That's the key. It established a framework that transcended all that tribal friction because it made the welfare of the Jewish community a state responsibility.
How so, specifically?
Well, it outlined that non-Muslims were guaranteed equal citizens under this new law. It made sure their life, their property, their places of worship, and their honor were all considered inviolable. By integrating their defense into the very structure of this nascent state, any attack on them became an attack on the sovereign authority itself.
So the commitment wasn't soft, it wasn't temporary, it was a formalization of rights that created what we would today call fundamental rights.
The earliest version of them, yes.
So let's really drill down into the specifics. The source material outlines what it calls the 7 pillars of minority rights established under early Islamic law. We can't just list them, we need to unpack the socio-economic and political impact of each one.
Absolutely. The first pillar was full religious freedom.
Okay, what does full mean in this context?
It meant not just the freedom to practice one's faith openly, but, and this is a crucial, freedom from coercion or undue influence. It wasn't simply tolerance, which kind of implies you're putting up with something unwelcome.
Right.
This was a positive right. It affirmed the legitimacy of the minority faith. And that contrasts so sharply with the state-enforced religious orthodoxies that were common in all the empire surrounding Arabia at that time.
Okay, so that's the first pillar. The second is legal protection from discrimination. That sounds critical for establishing actual citizenship. What did that mean on a practical, day-to-day level?
It meant legal parity. It ensured that the law applied equally, regardless of faith, at least in terms of criminal justice and basic protection. But, and this is a really sophisticated part of it, the system also respected the existing legal traditions of the Jewish community.
What do you mean?
They were often permitted to settle their own civil disputes, things like marriage, divorce, inheritance, using their own religious courts and their own laws, the halakha.
So it's a dual system.
It's a very sophisticated form of pluralism. It recognizes the spiritual and communal autonomy of the minority, while at the same time demanding loyalty and parity in public law.
That concept, legal autonomy within a sovereign state, I mean, that's still a challenge for modern liberal democracies today. It suggests a level of legal sophistication that is often, really understated.
It is.
Okay, what about the physical safeguards?
That's the third pillar, the protection of houses of worship. And this is such a powerful, tangible guarantee. It says that their communal life is not just permitted, it's actively secured by the state.
So this wasn't just about mosques.
Oh no. The source material is emphatic. This guarantee extended to synagogues, to churches, to monasteries, any place of non-Muslim worship. It declares that the sacred spaces of the minority are secured by the sovereign. It affirms the state's respect for the dignity of their communal life.
Wow. Okay, pillar 4.
Fourth was equal access to justice. This meant that in any dispute that involved members of the majority or that concerned public order, Their legal claims were treated with the exact same weight as those of a Muslim citizen.
So you couldn't use your status as a Muslim to just arbitrarily dismiss the testimony or the claim of a non-Muslim citizen.
You couldn't. The law was meant to be blind to faith in that context.
And the fifth pillar is often the most ethically critical one, especially when you're talking about historical state formation, no forced conversion.
Monumentally important. And the genius of this is multifaceted. Ethically, it enshrines freedom of belief and the sanctity of individual conscience. It's a rejection of using state power to achieve religious uniformity.
But there's a political dimension too, right?
A huge one. Politically and economically, it was revolutionary. I mean, if you look at the Roman Empire or others, converting populations was often a tool of integration and homogenization.
A way to make everyone the same.
Exactly. By rejecting forced conversion, the early Islamic state explicitly chose pluralism over homogeneity and conscience over coercion.
Which brings us directly to the sixth pillar, the system of tax protections. This is where the socio-economic reality of minority status really becomes visible. We are talking about the system involving jizya and zakat.
Right, and this requires some careful explanation based on what the source material says. Zakat was a wealth tax, a form of charity, levied on Muslims for community welfare. Non-Muslim citizens were generally exempt from this.
Okay.
Instead, they paid the jizya, which is often translated as the poll tax. But the source material's analysis here is key. This tax was not levied as a punishment. It wasn't a penalty for being non-Muslim.
What was it then?
It was an explicit exchange for specific civil rights and protections.
An exchange, like a contract.
In a way, yes. Crucially, paying the jizya exempted non-Muslim citizens from mandatory military service.
Ah, okay.
And that's a critical burden in a state that is constantly engaged in defense and expansion. It was essentially payment in exchange for state-provided security and protection of their life and property without them having to bear arms for the majority.
So it's a specialized civic duty.
You could see it that way. Plus, they were protected from the Muslim legal system's required charity contributions and certain other obligations. It provided a kind of economic equity and a distinct legal status. It ensured their financial standing was based on their constitutional agreement, not forced integration.
So rather than being subjugated, they were differentiated, with a legal mechanism that defined their mutual responsibilities and granted them a specific protected role within the state structure.
Exactly. And the seventh and final pillar, social and honor protections. This rounds out the whole holistic framework.
What does that mean, honor protections?
It went beyond just preventing physical harm or having your property confiscated. It was about ensuring dignity and respect. It recognized that a true legal shield has to defend a person's honor, their social standing, their reputation, just as rigorously as it defends their possessions.
So things like verbal abuse or discrimination based on faith were meant to be punishable.
Yes. It was about creating a society where they could live without being debased.
The genius, then, it wasn't just in the legislation itself, but in embedding this obligation deep into the moral fabric of the ruling power.
That's the key. It transforms from just a bureaucratic policy into a profound ethical demand.
And the source provides some specific quotes that really drive this home.
It does. To illustrate that ethical depth, there are two specific quotes from the Prophet that define the required commitment. The first is, "Whoever harms a non-Muslim citizen harms me." Think about that. The personalization of accountability. It places the ultimate state authority in direct personal defense of the minority. A violation of their rights isn't just a misdemeanor, it's a direct personal affront to the sovereign.
That makes it an absolute moral deterrent. It's much stronger than any mere penal code.
It's meant to be.
That moral deterrence is absolutely critical. But what mechanisms were in place, say, in later Islamic history when that moral deterrence failed? When a ruler didn't live up to it? Did the law provide judicial recourse, or was the protection purely an ethical constraint?
Well, the Charter itself established a political system where disputes could be brought to the central authority for mediation. But the long-term protection relied heavily on the precedent that was set. The concept of the dhimma, the covenant of protection, it became a binding legal principle in later Islamic jurisprudence.
So when rulers failed,
they were judged by this original covenant. The ethical constraint was meant to be reinforced by the religious consequences.
Which brings us to the second quote.
The second quote reinforces this absolute ethical barrier by binding it to the most profound spiritual consequence imaginable. It says, "The one who kills a non-Muslim under covenant shall not smell the fragrance of paradise."
That's absolute.
It binds the commitment to protection to salvation itself. So the state didn't just legislate minority protection, it declared it a sacred duty. This is why the Charter of Madinah is positioned as this revolutionary blueprint. It fundamentally altered the definition of statehood to include the defense and the dignity of the non-majority from the very, very first moment.
That is a remarkable and incredibly detailed foundation. So the key lesson from the 7th century is that a truly secure state builds constitutional guarantees for its minority groups, and it anchors those guarantees in the highest possible ethical mandates.
I think that's a perfect summary.
Now here's where it gets really interesting. We are about to jump over a millennium. We're going from the foundational moment of a religious republic to the height of a global secular crisis. We're traversing continents and cultures, and yet
the fundamental legal struggle remains the same.
Exactly the same. The defense of individual conscience against the coercive impulse of the state. We are transitioning now to West Virginia State Board of Education v. Barnette, decided by the U.S. Supreme Court in 1943. And the historical context is just. It's essential for understanding the dramatic stakes here.
Absolutely. It's World War II.
The United States is fully embroiled in World War II. The fear of internal disloyalty, of fifth columns, of espionage, was absolutely rampant. The government was desperate to forge absolute national unity.
And the symbol of that unity was the flag.
The primary symbol, a mandatory daily requirement that all school children had to salute the American flag.
And this atmosphere, it turned what seems like a simple patriotic ritual into a test of loyalty, which in turn created an existential crisis for a small minority group, the Jehovah's Witnesses.
Explain their position. Why was this an existential crisis for them?
Their theological position was based on a very literal interpretation of the Old Testament, specifically Exodus 20, the part that forbids idolatry. For them, the flag salute was precisely that. It was bowing down to a graven image.
So for them, refusing the salute wasn't an act of disloyalty to the country?
No, not at all. It was an act of absolute non-negotiable loyalty to God.
And the political system, driven by this wartime urgency and, frankly, majority hysteria, it did not tolerate this moral stand. The consequences for these children and their families were horrific. They illustrate the brutal reality of forced conformity when the state aligns itself with majority sentiment.
They faced swift and severe institutional punishment. The children were expelled from public schools, suddenly deprived of an education.
And under state law, that led to
their parents being prosecuted and jailed for failing to ensure their children's education. But beyond the judicial persecution, they endured this intense social ostracization and, tragically, widespread mob violence from communities who saw their principled refusal as treasonous, as disloyalty during a time of war.
Now, this was actually the second time this issue had reached the Supreme Court. Just 3 years earlier, in 1940, the court had ruled in Minersville's School District v. Gobitis that the flag salute could be compulsory. They prioritized national unity.
They did.
So why, just 3 years later, did the court choose to hear the case again and reverse itself so dramatically?
That pivot is key to understanding the importance of the Barnette case. The Gobitis decision had immediately led to this wave of anti-Jehovah's Witness violence across the country. It proved that a judicial error could actually embolden mob rule.
So the court saw the real-world consequences of its decision.
They did. They realized their prior ruling didn't foster unity at all. It actively facilitated the persecution of a vulnerable minority. By 1943, the stakes were crystal clear. Could a republic that was fighting fascism abroad adopt the coercive uniformity of fascism at home?
A powerful question.
So the case reaching the Supreme Court was this high-stakes challenge to the limits of state power during a national emergency. Could the state compel belief or expression under the guise of unity? And the court, by a 6-3 vote, answered with a resounding no.
And they used the First Amendment.
The First Amendment's guarantees of free speech and religion, which were applied to the states through the 14th Amendment.
Let's break down that mechanism quickly. For our listeners who might not be deep in U.S. constitutional law, why was the 14th Amendment the legal shield here? Why was it necessary?
That's an excellent point. The First Amendment originally primarily restricts the federal government. It's the 14th Amendment, specifically its due process clause, that allow the Supreme Court to incorporate those First Amendment protections and apply them against the state government of West Virginia.
So it's a bridge.
It's a critical bridge. It's the doctrine of incorporation. It means the state cannot abuse its power by violating fundamental federal rights. The court was basically telling West Virginia, you cannot do what the federal government is forbidden from doing, which is mandate political orthodoxy.
And the judgment that came out of this is defined by Justice Robert Jackson's powerful ratio, dissidende, the legal principle on which the case was decided. The source material highlights this as one of the most powerful defenses of individual liberty ever written.
It is. It really is. Justice Jackson wrote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or opinion."
That quote is just. It's the ultimate defense of the individual mind against the collective will. It tells us that the state, even in times of existential crisis, cannot reach into the realm of private conscience and dictate belief or non-belief. But let's analyze the scope of that quote for a second. He specified politics, nationalism, religion, or opinion. Why define orthodoxy so broadly?
Because the state's impulse for coercion doesn't just manifest in religious tests. It manifests in forcing political conformity. By linking religion, nationalism, and general opinion, Jackson created this comprehensive firewall. He recognized that compelling the flag salute was not an exercise in education.
It was an exercise in coercion.
Exactly. The state was forcing individuals to speak a message they did not believe, thereby violating the fundamental freedom of expression and of conscience.
So Barnette protected minorities from this forced conformity by establishing what the source calls 4 bedrock principles.
Right. First was the deep protection of religious liberty. Second was the fundamental freedom of conscience, the right to hold a belief and act according to it. Third, a really firm protection against state coercion, limiting the state's ability to force patriotic display or adherence to official dogma.
And the fourth one is maybe the most important.
It's crucial. The fourth principle is that minority rights must be protected even against intense majority pressure. This is the moment the Supreme Court declared that the majority cannot demand the subjugation of the individual conscience for the sake of a manufactured political harmony.
The right to be different.
Is the very meaning of American liberty, according to Jackson.
And if we just pause here for a moment and connect the echoes, as our source material suggests we should, the continuity is just astonishing.
It really is.
In the 7th century, the law protected the minority from having their places of worship desecrated or their faith forcibly changed. In the 20th century, the law protected the minority from being forced to express a loyalty or belief that violated their conscience.
The technical implementation is different. A written charter versus a judicial interpretation of an amendment. But the core ethical goal is identical.
Protecting the individual identity and belief system from state pressure and from majority rule.
That continuity is the core insight of this entire comparative study. It shows that the principle that law must protect the inner life and distinct identity of the citizen is not geographically exclusive. It's not historically limited to any single cultural tradition.
It's something more fundamental.
It is perhaps an inherent ethical constraint that just emerges whenever true statecraft is attempted. Whether it's written into a charter in Medina or interpreted through the U.S. Constitution, the moral imperative to protect the dissenter is the same.
Okay, so now we move forward into the 21st century. We transition to a case that demonstrates how contemporary judicial systems actively affirm and enforce these ancient and modern principles. We're discussing the Suamoto case number 1 of 2014 in Pakistan.
Right.
The context here is tragically immediate and modern. Unlike Barnette, which was about a test of conscience, this case was born from an existential physical threat.
A very real one.
The catalyst for this judicial intervention was a devastating and deadly terrorist attack on a church in Peshawar. This act of targeted violence forced the judiciary to confront comprehensively the structural and existential insecurity faced by the nation's minorities, Christians, Hindus, Sikhs, and others.
And this case is a profound example of judicial activism, and specifically the court acting suamoto.
Explain that term for the listener. Suamoto.
It's a critical term here. It means the Supreme Court initiated the proceedings entirely on its own motion. There was no external litigant, no political party petitioning it.
Court just decided to act.
Exactly. It demonstrates an institutional recognition of a systemic crisis. The court basically said the executive and legislative branches had failed to protect the vulnerable, forcing the judiciary to step in as the ultimate shield.
And the judge presiding, Justice Tassaduq Hussain Jilani, he issued a landmark declaration that profoundly expanded the definition of basic rights in the country.
He did. His statement was foundational. He declared that the right to life includes the right to live with dignity, security, and without fear of violence or discrimination.
That is a crucial expansion of Article 9 of the Pakistani Constitution, the right to life. By linking the right to life not just to physical survival, but to dignity and freedom from fear, The court created an active duty for the state.
It's a major shift.
It moved beyond just preventing the state from causing harm and required the state to actively guarantee a safe, dignified, and fear-free environment for its minorities.
Absolutely. Yeah. This judgment was revolutionary because it recognized that violence, that discrimination, the constant threat of persecution, they erode dignity, and therefore they violate the constitutional right to life itself. The court recognized that protection must be comprehensive. It has to target not just the physical perpetrators of violence, but the systemic roots of discrimination and hatred.
And the source material emphasizes that this wasn't just a philosophical statement. It led to 5 specific, mandatory, actionable steps that the Supreme Court ordered the federal and provincial governments to implement.
Yes, these were administrative and legislative mandates, forcing the government to structurally change how it deals with minority rights.
So it wasn't just talk.
Not at all. The court's orders demonstrated a comprehensive approach to protection. It was about bridging constitutional theory with administrative reality.
What was the first order?
The first order was the establishment of a National Council for Minorities. This institutionalizes the focus on minority issues. A dedicated council ensures continuous institutional monitoring, policy input, and it provides a specific, high-level voice for these communities at the federal level.
So it transforms intermittent goodwill into a permanent administrative structure.
Exactly. It ensures minorities are active stakeholders in their own protection.
And the second order, it focused on that foundational physical safeguard we saw echoed all the way back in the Charter of Madinah.
Protection of worship places. The state was mandated to secure all minority places of worship, churches, temples, gurdwaras, you name it, recognizing them as vulnerable public assets that require state defense against extremist elements.
Third,
they ordered the fast-track prosecution of hate crimes. This is so critical for deterrence and for restoring confidence in the judicial system. Targeted violence often goes unpunished because of procedural delays, political interference, or just poor police work. By mandating fast-track courts, the Supreme Court ensured that crimes motivated by prejudice are treated with the utmost legal priority and concluded swiftly. That's essential for rebuilding security and trust among minorities.
The fourth order seems like the most ambitious. It targeted the ideological source of the prejudice, the educational system.
It was. The court demanded curriculum reform to eliminate hate material. Now, this is arguably the most challenging administrative hurdle. Removing subtle, systemic propagation of discrimination and historical inaccuracies from established educational texts. That's a massive and politically sensitive undertaking.
It's an explicit attempt to drain the swamp of deep-seated prejudice at its source.
It is. It's an acknowledgement that legal protection is useless if the next generation is being taught to hate.
That order alone speaks volumes about the court's determination to address the problem systemically, not just symptomatically.
And finally, the fifth order placed the burden squarely on the state. Federal and provincial government responsibility to protect minorities. This makes protection an undeniable constitutional duty. It ensures accountability across all levels of governance and provides legal justification for future action against any non-compliant officials.
What's so powerful here and what makes this judgment so relevant to our deep dive is how it anchors its mandate.
Yes, it's a dual foundation. It's modern constitutional law and Islamic values. The court actively quoted Islamic sources, including the Prophet Tahir's covenants and historical precedents for protecting non-Muslim citizens. It did this to align constitutional rights with deeply rooted tradition.
So it's a synthesis.
A powerful one. It reinforces the legitimacy and the depth of the protection. It demonstrates that contemporary protection isn't some foreign import, but a robust reaffirmation of the nation's own ethical origins. It echoes the very first pillar we discussed.
So what does this all mean? We've traveled through time. From a 7th century covenant that defined statehood, through a 20th century defense of conscience in a secular republic, to a 21st century judicial mandate reaffirming pluralism in an Islamic republic. And the enduring legal principles are startlingly, consistently, and specifically aligned.
They are.
Let's transition now to the ultimate synthesis. We have to move beyond just noting the similarities and start discussing the implications of this shared ethical code. Is this a case of, legal diffusion, one idea spreading, or does it point to something more fundamental, a universal ethical constraint on sovereignty that just appears independently in different legal traditions?
That is the ultimate question the source material poses. And I think we can structure the analysis around the comparative legal principles outlined in the sources, showing the essential constancy across time and geography.
Okay, let's do that.
Let's re-examine our 3 legal pillars through 4 key dimensions. Let's start with the minority protected.
Right. In the 7th century charter, it was the Jewish minority explicitly shielded.
Hmm. In the 20th century, Barnette protected religious minorities, the Jehovah's Witnesses, from forced conformity.
And in 21st century Pakistan, the Supreme Court judgment protects Christians, Hindus, Sikhs, and others, issuing these comprehensive administrative protections.
So the subject of the protection shifts, but the principle of shielding the fewer remains constant.
Okay, the second dimension, the foundational principle. This is where we see the essence of the ethical command. In the 7th century, the rule was personalized, it was absolute. Whoever harms a minority harms me. It's a direct, visceral identification of the sovereign with the vulnerable.
Right. Then you transition to 20th century America, and the principle becomes institutional and systemic. No official can impose orthodoxy. This is a structural check against the abuse of state authority. It prioritizes what philosophers would call negative liberty, freedom from state control.
And in 21st century Pakistan,
The principle is articulated as an active, positive mandate. Minorities must be protected constitutionally and administratively. It moves from a prohibition against state harm to a positive administrative duty of continuous protection.
so whether it's personal, prohibitive, or active,
All three statements serve the same foundational purpose, placing a structural restraint on the majority's impulse to dominate and demanding dignity for the few.
okay, our third comparative point focuses on the sanctity of belief, worship, and conscience.
The Charter guaranteed that houses of worship were secured and protected.
Barnette upheld the freedom of conscience, the right not to participate in the majority's ritual.
And the 2014 SC judgment mandated that the state must actively secure places of worship and, importantly, reform the curriculum to protect conscience from ideological harm.
That demonstrates a clear progression, doesn't it? From a passive defense to active security and even intellectual protection.
It does. But the underlying value, that sacred space and belief are inviolable, that remains the universal constant.
And the final comparison, legal standing.
The Charter ensured full legal equality and these autonomous legal mechanisms for non-Muslim citizens. Barnette cemented equality under the First and 14th Amendments, ensuring minority expression couldn't be silenced by majority nationalism.
And the 2014 judgment guaranteed equality under specific constitutional articles, reaffirming these rights within a modern codified framework and providing specific administrative remedies for violations.
The common thread, this shared ethical consensus spanning 14 centuries and global cultures, it's undeniably present.
It almost seems irrelevant whether the foundation is a religious covenant or a secular constitutional doctrine. The outcome, when it's properly applied by a conscientious judiciary or ruler, is the same: the defense of the vulnerable.
It does seem that way.
But I have to ask, does this continuity mean that progress is irrelevant? We see the same principles reappearing? Are we just relearning the same moral lessons every few centuries?
I think the source material suggests something a bit more nuanced. It suggests that the moral lesson is constant, but the tools of protection evolve. And that is where progress lies.
Okay, explain that.
The 7th century system relied on a very high degree of personal moral commitment from the sovereign, which was backed by spiritual consequence. The 20th century system relied on judicial interpretation and the strength of a written constitution to stop coercion.
And the 21st century system.
The 21st century system, particularly in the Pakistan case, recognizes that modern threats require modern administrative solutions: a national council, curriculum reform, specialized courts to fight systemic prejudice. The moral core is fixed, but the legal mechanism for enforcement must become increasingly sophisticated to meet evolving threats.
I see.
And that brings us to the ultimate synthesis, the ratio de gen, the core lesson. Derived from this comprehensive comparative analysis, it's clear and it's universally applicable. The dignity, safety, and freedom of minorities define the moral strength of a nation. A majority that protects its minorities becomes a civilization.
That's powerful because it strips away all the political rhetoric. It simplifies the moral test of governance down to that one metric. The source material's historical impact summary clarifies the unique contribution of each era to this overarching ethical code.
Right. It says Islam pioneered minority rights, creating the foundational legal concept of institutionalized, protected pluralism.
Then America defended conscience against state coercion, establishing the individual's moral autonomy against the patriotic or nationalistic demands of the collective state.
And Pakistan's Supreme Court reaffirmed Islamic and constitutional values, demonstrating that these principles can and must be robustly enforced in the modern digital era against both internal threats and external extremism.
So it's the universal message, the ultimate conclusion of this comparative research. A nation is judged not by how it treats its majority, but how it protects those who are fewer, weaker, or different. This discussion has been profoundly illuminating, and I want to thank you. It's really thanks to the comprehensive research that underpins these comparisons. What we've witnessed is that the greatest legal accomplishments, the moments that truly mark the evolution of civilization, they're not the ones that empower the ruling class.
No.
They're the ones that create an unshakable defense for the margins of society.
Mm-hmm.
The ultimate moral for you, the listener, today, as articulated by the source material, is both simple and absolutely critical. A society with secure minorities is a society with a secure future. Security, dignity, and freedom. They're not zero-sum. They are mutually reinforcing. When you shield the vulnerable, you secure the entire structure.
And if that's true, if the protection of minority rights is indeed the measure of a civilization's moral strength, then we have to ask ourselves about the immediate application of this knowledge. We've looked at historical and constitutional precedents, but these principles are active today. They're playing out in real-time policy and in community discussions.
Right now.
So consider this. What current global policies or community discussions, and I'm thinking about debates on mandatory public prayer in schools, or the use of language laws to marginalize smaller linguistic groups, or the protection of transgender rights. Which of these demonstrate the immediate moral strength or weakness of the society you inhabit today?
The tough question.
It is. But is the current debate prioritizing the dignity, security, and freedom of the minority? Or is it prioritizing the coercive impulse and the comfort of the majority?
That's the test.
We encourage you to take this framework, the 7th century duty of protection, the 20th century defense of conscience, and the 21st century mandate for administrative security, and use it as a measure. The enduring choice to extend the shield is what defines us.
Continue your own exploration of these vital concepts. Until next time.